you are holding on to some very sensitive data here. You don't need me to tell you that, of course. And if your clients see that it's not secure, well, they might not stay your clients for that much longer. Now, of course, if something does happen, then you're looking at the possibility of client identity theft or possibly even civil liability. Now, one thing to realize with the civil liability, that's sort of developing at this point. A lot of the cases that are being brought are having trouble getting past what's called a standing issue, which effectively means the people trying to bring the suit don't actually have the right to sue. The reason they're coming up with this is because the idea of the injury is sort of off in the future. Like, well, okay, our records have been stolen, but nothing's happened. Legally speaking, this is referred to as an injury in fact requirement. So at this point, those cases tend not to go ahead that far. There's even one extreme example I would mention out of the Eastern District of Missouri, which is a federal court there, from 2009. It's a case called Ambergy versus Express Scripts. And this one held that there was no injury, even though the defendants not only got notified of the data breach, their records had been stolen, they actually got not one, but two extortion letters sent to them saying, yeah, pay us or we're going to send the stuff. And they didn't pay, stuff got sent, and there was still no liability found. Now that said, many of these cases are still brought and they will continue to be brought because there's a potential there. And of course, just to avoid the litigation, a number of these cases do settle for high amounts. Can this add up? In short, yes, they can. Now, a more general consideration you might want to think about would be the actual state laws which apply to breach notification. So let's say something's been taken out of your system, personally identifiable information or something else sensitive. If it's been sent out, if it's been taken away, you might have to actually make a public notification to your clients. That's embarrassing. You certainly don't want to do that, and God forbid it gets out in the newspaper. And this has certainly happened in a variety of businesses. I'm sure you've read about them. Now, as far as a national law that's still being debated, hasn't come out yet, but 47 of 50 states do have requirements for notification of a data breach. Generally, this applies to unencrypted data. Encryption is when you use an algorithm to take data and scramble it, so it comes out looking almost like gibberish. But in effect, if it's encrypted, for most state laws, even if it's stolen, it's considered as unreadable, and thus you don't have to make the notification. I'll talk a little bit more about encryption later and the details of it. As for those 47 states, it's probably easier to mention the three exceptions, which are Kentucky, New Mexico, and South Dakota. Now, a few states have more stringent requirements. In particular, Nevada, Massachusetts, and Washington require that any client data that is sent electronically or is held on a mobile device has to be encrypted. And the Massachusetts law is actually pretty notable because it applies extraterritorially, which means that if you're dealing with a Massachusetts client, but your own firm is not based in Massachusetts, you still have to adhere to the requirements of the Massachusetts law to guard what you're looking at there.